in the training, especially on SGBV in elections, because we cannot forget that SGBV is one of the main election offenses that we have witnessed. For example, in our 2017 report, the Commission recorded 210 cases of SGBV in elections that were committed in the areas that we had mapped as hotspot areas. And these are only the reported cases. You know that there are cases that go unreported. So I wanted to hear and to also see the preparedness of the Office of Director of Public Prosecution when it comes to the prosecution of these SGBV cases, especially in the context of election, because we know it's different from the normal SGBV. We also have SGBV being used as a hate crime, and that is some of the emerging issues in our jurisprudence, and we have seen the judiciary, with the leadership of Honorable Chief Justice Martha Koome, have a specialized court in Kwale to deal with SGBV. So this is something that Madam Jacinta and the team will want, for example, to guide us, and also will want to seek more clarification on how the prosecutors are prepared to handle SGBV cases in election. We also, as a country, we don't have a deficit of laws. We have so many laws, but the problem is when it comes to enforcement of these laws. I want to give you an example of when we have county governments and national government going to launch project, for example, so that it can give them, for example, unfair advantage when it comes to their opponents. We have a law that protects that, but the problem is the implementation of these laws. So even from the Office of Director of Public Prosecution, the preparedness as a country to ensure the enforcement of these laws is something that as a commission will be observing and will want to see in this election. Thank you. I also feel maybe the last point, I also commend the training because actually it gave a very human rights-based approach when it comes to prosecution of election offenses. And that is something to commend the ODPP on because it is building the capacity of the prosecutors to just have sort of a human rights responsive prosecution on election matters. Thank you.
Thank you so much, Lillian. We can now hear some thoughts from IPOA. As we listen to what IPOA is going to tell us, we can ponder on what Madam Lillian has talked about, the offenses of SGBV during elections. We shall be coming back to you.
Good morning, everyone. My name is Diana Watila. I work in the Independent Policing Oversight Authority under the Complaints Department. I know lawyers at times you see us like the way a doctor would look at a herbalist, but we are very essential. We prevent you from dealing with a lot of messes. And we want to thank you very much for the training. I'll tell you a little bit about IPOA, so to show the nexus between IPOA, ODPP, and the issues of elections. So Independent Policing Oversight Authority is there to ensure the realization of Article 244 of the Constitution to enhance professionalism within the police. It is often seen as a very punitive function, but our role is to ensure that police enhance to professionalism and protect human rights. And we have currently put in place a framework to support interagency collaboration during the elections, including training of police officers, training of monitors. We also have a toll-free number, it's 1559, where people can call to receive assistance. And our key roles are to ensure that we investigate and cases of police misconduct, such as serious injuries and deaths. And I want to reiterate what my colleague from Kenya National raised, that one of the key things that we cannot run away from is the aspect of electoral security and how electoral violence is used as a form of manipulating elections results. It can either be done as a way of disenfranchising voters. You have seen in areas where someone will make it so chaotic in areas that he cannot get votes and people do not vote. It's also back to the issue of gender-based violence. Women are very vulnerable. They are not really vulnerable, but in every community, the person who props up the community is a woman. So if you break her down, you break her down the daughter, you've broken down the community. that is why you'll see people going against women. So it's something very serious where either police fail to protect members of the public, and we've seen that there was a recent ruling where Coalition Against Violence and ICJ had, and among other people, had filed a petition. And the court found that the police were negligent in their duties and they also abused. So that is a very serious issue. I think we need to look further. We've also said we need to understand who are these perpetrators of violence and how they'll be dealt with. What are the root causes of violence? Is it political exclusion? Is it social? Is it ethnic? Are there private motives? We are seeing a few things happening in the media. I saw a few months ago where a senior politician was literally chased from someone's compound because he's gone to visit the wife without permission. You see, we all saw that. Why was that done? It could be a form of embarrassment. We also have to look at one of the things that ODPP might have to look at is how prosecution of election violence. And there are many challenges in that because at that point it's very difficult to document because the members of National Police Service have priorities. For example, they might be barricaded in the station, protecting people. They're overstretched, they've been on duty the whole time. But you'll find there that during that point, during especially the pre-election, during nomination, there's issues of violence. During election day, it's normally calm, but after that, there's an explosion. And you find that you're getting cases of deaths, serious injuries, issues of public order, management. And one of the things that we really need to look at as we are prosecuting is just stick to the rules of use of force. Was it proportionate? Was it legal? Was it accountable? Was it necessary? When it comes to aspects of public order management, the things you have to look at is what is the role of the commander? In these places, there's control. He has to have command and control. And he's the only one who is allowed to issue the orders to use lethal forms of force. So there is need to understand policing operations, what responsibility is whose, and where there's the blue code of silence, it would be good to go after the commander because he's the one responsible. Another thing, we should never forget our role as public servants because we are supposed to uphold human rights. We're supposed to work together. We also have to be aware. We need to monitor hotspots. It will give you an indication of the types of cases you will get. Like right now, you're seeing a lot of people moving from Nairobi, informal settlements, going home. That should be an indicator. So thank you very much. I will stop there.
It's time to welcome Your Honor, Madam Edna.
Thank you very much for this opportunity. For me, this workshop was very good. It was well organized and the speakers were very good. The content was very relevant to our work. But I must say that all of us are important in administering, in ensuring that people access justice. Because if the investigating officer does not investigate the case well, you don't expect the judiciary to convict. And for IPOA and for the National Commission on Human Rights, yes, I agree that there are so many SGBV cases, but the reports you generate, can they translate into admissible evidence for the prosecutor? Because if you go and tell the prosecutor that there was SGBV, the prosecutor, the DPP, they have their guidelines on charging, so they will not charge unless that case meets the threshold. So as you document, you need to identify credible witnesses who can come and stand in court and actually testify that it actually happened. And for us in the judiciary, we just administer the law. And we make our decisions based on the evidence that is brought to us, not on what reports people have documented. You may have documented. I worked with the National Commission on Human Rights, and we did a lot of investigations on human rights violations. But none of those investigations can meet the test of charging anybody in court. So they just remain reports. And number two, prosecuting cases of hate speech, there's a challenge because we have hate speech under the NCIC Act, and then we have hate speech under the Penal Code. So there's a disconnect. Who is going to trigger the Law Reform Commission to amend the law so that we have the law is very clear. So when the prosecutor is actually taking the case to court, I can actually look at the charge sheet and say, yes, this prosecutor and the investigating officer, they have done a good job. But you know, when people are arrested and brought to court because there's public outcry, there's nothing we can do. Even if when I force my colleague Kemo, tell Kemo, bring a charge sheet so that even if it's defective, you will amend. Kemo knows that there's nothing to amend. So you see, that is the challenge. That's the challenge that we are facing. So we need to work together. We are all colleagues, even the police, you know, they are our brothers, they are our sisters. We have to treat them very well. When a police officer comes to court and they have not prepared very well, tell them in a nice way, because, you know, he is a human being. He has a face to save. Tell him in a nice way that, you know, you need to bond the witness. Don't start embarrassing that police officer and making him lose face, because at the end of the day, he's somebody's husband, he's somebody's boyfriend, he's somebody's girlfriend. You see, and you see nowadays with the social media, these things are, you know, they are shared on YouTube. They are shared on YouTube very fast. You see, in a short while, you'll see your name trending. As a magistrate, every station I work in, through the CUC, we always develop a bond with the prosecutors, with the police. We work very well because we work towards achieving something that protects this country. And that's why, like in all the stations I have worked, we don't have to bond at the work, because when I'm in court, I rearrange my face and I'm serious. But when we are out there, we can bond informally and point out, these are the mistakes you are making, please improve. There have been cases where you find a prosecutor comes and stands in court and says, I leave it to court. And you see this battalion of lawyers, the likes of Ogada, have brought very good submissions. You see, you cannot just sit and say, I leave it to the court. You see, you are professionals. You are advocates of the High Court. And you need to demonstrate to me that even you went to a proper law school. You did not go to law school through the window. And then when prosecutors make mistakes, also let them save face. You can take a short break. Tell the court, oh, I'm taking a mask break. When we were wearing masks, I'm taking a mask break. I need to breathe fresh air. Then you call the prosecutor, and you tell the prosecutor in the privacy of your chambers, why are you killing the case? You have not produced the documents. Then the prosecutor goes, and you know, they are very confident. And even us, we have learned from prosecutors. When I was appointed as a magistrate, I was a DM2, and I did not know anything. I had just come from wherever I came from. I did not understand the procedures, and I made a grave mistake in court, in open court. And the person who corrected me was a police constable. He was called Radak. May God rest his soul in peace. Radak was a very good prosecutor, very effective. In fact, he was better than the inspectors and the chief inspectors who used to prosecute, such that everybody wanted Radak to prosecute. So Radak came and corrected me, and I learned. I learned very fast. So we are all learning. You can even learn from an intern. You just be open and open-minded. So I think maybe I'll invite questions when the time comes. I'll give to the next speaker.
Thank you so much, Madam Edna. Mr. Okal.
Thank you very much. As you rightly put it, my name is George Mwangi Okal. People normally have issues with my middle name, but I say I'm a Kenyan. Section 87 of the National Police Service Act. It more or less performs the same role as IPOA, because we receive and investigate complaints against the police. We also ensure that we maintain the standard of discipline and good order in the National Police Service. We also, in the performance of our duty, we also receive, we investigate complaints on the directions of Inspector General of Police, the Director of Public Prosecutions, National Police Service Commission, IPOA, and IPOA. So today, the training today also is important to us because most of the prosecutors normally confuse Internal Affairs Unit and IPOA. To me, this is the right forum for us to explain that, you know, IPOA is our big brother because they have the overall oversight over the National Police Service, including Internal Affairs Unit. The training, the workshop, which was organized by the ODPP, to me is a good eye-opener because it embraces that multi-agency approach, what we have been agitating for, that even we, the National Police Service, we cannot work alone. We need the services and the support of other institutions. And coming together, organizing this forum, and also inviting other stakeholders to come in is very important. It's speaking volumes, and we really encourage that. The other thing that we've learned is the respect for institution mandates. I think for the past, there have been issues between the ODPP and the National Police Service on matters of prosecutions. Even some people rush to court on some flimsy grounds. But it's good that the record was set, that the issue of prosecution lies squarely on the ODPP, and we really appreciate that. So us, as the National Police Service, is to support the DPP with the necessary material so that you realize your objectives. And we will do that unconditionally. The other thing we've learned also is for the ODPP opening its doors for consultations. I've attended, this is the second forum. The first forum I attended was in Kayole. That was organized by human rights organizations. And it was presided over by the DPP himself. We were also invited, where we received questions from the slum dwellers. And it was like the ODPP also embracing the reforms and also opening its doors. And also what we have opened today, giving opportunity to other institutions also to come and witness what we are doing, give inputs, criticize, and also support where necessary. On the National Police Service, you know, we play a very critical role. Now, everybody is looking at the police because of the critical police plays when it comes to elections. We are tasked to ensure that we maintain law and order. We also to protect life and property. When that prosecutor, his life is in danger, he runs to the police. So our work normally, after elections, police normally are always at the receiving end. From 2008, when we were really, the functions of the police were really put into acid test, we've tried from 2007 up to date to embrace reforms. The reforms which were majorly factored in the Ransley report, which also gave birth to IPOA and the Internal Affairs Unit. We've tried to institutionalize many reforms. For example, we've come to know that our basic mandate is to investigate crime and provide evidence to the prosecutors so that cases in court do not collapse. We are doing this without any partiality to ensure that each and every person in the country gets justice. But sometimes, you know, police are under pressure, especially during this electioneering period. You find that politicians are hiring goons, attacking the opponents, and then the police are expected to do diligent work to curtail the thuggery. And that we have been doing. What we just call for is the support for every institution, the judiciary, the prosecutions, and other critical players in the criminal justice system. The other thing also that I would also wish to highlight is about consultative meetings we've been having with ODPP, IPOA, and the National Police Service Commission. Of late, we have seen areas where the NGOs, the non-state actors, they don't want us to speak from different scripts because they know we need one another. So they've been organizing these consultative meetings so that we can be able to compare notes and see areas where we can support each other. And this thing we've realized it has really helped us a lot. And we are still calling for more of such meetings so that we can be able to realize our mandates. We are also in realization that through the work of the DPP, we managed to develop standard operating procedures. I think each and every prosecutor should be able to get these SOPs which were developed. Because these were developed because there were some teething problems. You know, IPOA, IAU, there are some overlap mandates and the National Police Service. So instead of fighting out there, we said that the ODPP said, no, I want to be the neutral person. I want to be the referee. Let us have these SOPs to help you realize your objectives. And it has been working well so that we work in harmony. We are not there to antagonize each other. So I'll still welcome your questions. In brief, that is what I've learned, and I still expect more. Thank you.
Thank you so much, Mr. Okal. Representative from Witness Protection Agency.
Yes. Thank you very much. My name is Biwot from Witness Protection Agency. And I want to state from the onset that I'm not a prosecutor. I'm not a lawyer. So I will call myself an operation person because I have a background in operations. So don't ask me so much on legal questions. So ask me about protection. Thank you. WPA is an independent agency. We are established under an Act of Parliament. In our 2010 Constitution, if you look at Article number 50, subsection 9, that is where we are found. First, I want to thank the ODPP for coming up with such workshops. And I want to say that we are honored as an agency for considering us to be part of this workshop. As we were going through the training, something that came up and I learned a lot. And also, having been an investigator, is that there was the issue of a decision to charge. And even as we look at the evidence test, I think a critical component also in that is the witness. And if the witness fails to come and testify before court, I want to believe that the case will not see the light of the day. And that is where us as Witness Protection Agency, we come in. When you have your witnesses, they've recorded their statements, and they are threatened, and they don't appear before court, then it becomes a problem. And that is basically our role. We protect witnesses who have been threatened on the basis or on the account of them giving statements to law enforcement agencies and other enforcement agencies. As an agency, we have regions. We have a region in Mombasa, where we opened in, I think around 2013, 2014. We also have a region in Kisumu and in Nairobi where we started. And we hopefully, we hope that in the near future, we are opening other regions across the country. I think that is basically what I will say, but our role is to protect witnesses. Thank you very much.
Thank you so much for your thoughts. And I'm sure there are issues that you brought out very well that we need to also contribute to. And from what, I'll skip what Madam Jacinta said, but I'll go to what Lillian said on the SGBV, which are committed during elections. So we've had challenges prosecuting those matters, especially when the evidence is not sufficient, or we cannot even get the witnesses, because by the time we get to know that these offenses were committed is way after, and maybe after some documentations has been done by the human rights NGOs. So some of the challenges that we've been facing, and this is an opportunity now to talk to the human rights, because as it has been mentioned by the magistrate that unless that which has been documented can be translated as evidence, it does not help us. So probably would want to ask questions to Madam Lillian. Why is it that when they go down there, because most of them they are there down, when things are happening, they're able to document, but when we look at the reports, we cannot really pick out who are the witnesses, what happened, where is the evidence that we can present in court, even though the offenses were committed. So probably, having listened to the international best practices, all those people are presented from Monday up to today, what has been happening in other jurisdictions, maybe it's an opportunity for us to interact with the panelists, and then we try to understand why is it that they give us reports which cannot translate to evidence for us to present in court. So I'll invite you so that we can ask questions and be open and be frank and be free so that we can deal with this session properly. Yes, someone was supposed to be helping me with there's some hand there, Madam Masharia.
Good morning, everyone. My name is Esther Macharia. I'm a prosecutor from Meru County. I wanted to ask my colleagues, my seniors prosecutors who are here, and also the Internal Affairs Unit. And my question is whether the decision of the Internal Affairs Unit is supposed to interfere with our decision to charge. I'm asking that because of, maybe I can give an example of a case I had in Meru, and there were 2 people who were arrested with traffic offenses, and they alleged that the way they were handled during arrest infringed their rights. So they made a complaint at the Internal Affairs Unit. And we also, the files also were forwarded to us to make a decision. According to us, there was enough evidence, and we made a decision to charge, and we charged those people with some offenses in court. When the matters were taken to court, the suspects filed a constitutional application in the High Court that their rights were infringed during the time of arrest. So the matters in the lower court were stopped, and the High Court decision was that we should discontinue the matters And the judge relied so much on the decision of Internal Affairs Unit. First of all, I want to ask whether the judge is supposed to rely on the decision of Internal Affairs Unit in making his decision. Secondly, when we were making our decision to charge, we were not privy of the decision of the Internal Affairs Unit. So my question is, even if you are aware of the decision, are we bound by it when we are making our decision? Because the decision by the High Court was that we should discontinue, the matters were discontinued in the High Court, and we were also told to pay damages as prosecution because of the misconduct of the police officers who arrested the suspects. Thank you.
Thank you so much, Madam Macharia. Do we take the questions first or we react to the questions? We take about 5. You note the question, and that's Madam Jacinta. Mtu wangu wa mkono. Njoo huku mbele. Yeah, give Penina.
Good afternoon all. My question is similar to what my senior Madam Esther has raised, because we experience the same problem when it comes to matter investigated by IPOA. We know there is that section in the IPOA Act, was it section 26, that provides that they cannot investigate a matter that is already subject to court proceedings. Yet we see most of the investigations from IPOA come way after a decision to charge has been made, and majority of these matters are already in court. As I don't know, maybe my seniors can answer me, what do we do? Because we are holding these matters in abeyance, but after that, how do we reopen them? Yet these are matters that are already proceeding before our courts. And maybe for the judiciary also, they can comment on, because I see most of us staying them. I don't know how the rest of you handle them.
Thank you so much. There was some hand up there.
Okay, thank you so much. My name is Namiti. Madam Jacinta, thank you so much for your presentation. And, coming up with this kind of, I want to say this, that when I was a young man in Meru, you came and prosecuted some case which emanated from, I think, Marsabit, and I'm happy you've secured a conviction. Should we also be having, does our office have some mentorship program? Because I learned a lot from the details of the prosecution that you and your team undertook. Should we also be having some mentorship program? I don't know about the PTI, but for just young advocates to learn how to prosecute these special cases, especially now that the election offenses is ripe. Secondly, in my last experience as a prosecutor in the last general elections, I was also part of the team that was trained for elections. And I think part of that time, Madam Frida was my boss, and he used to send me to some courts in Maua, Kubu, to handle some cases, election matters. Then when you reach to a court, that the judicial officer, now this is for Madam Judiciary, I don't know whether that is the thinking in all the judicial officers, that isn't the prosecutor that I have more competent enough to handle this particular case than the one that has been sent from, I don't know from where. So he becomes uncomfortable for me to go and handle that particular election officer's case. And that is why we have this small training. We are about 80. We have over, I think, 1,000 prosecutors. Is that the thinking in the judiciary? Then I just want to thank the IPOA. You always bring witnesses, even in the remotest part of the country, in Baragoi, and keep up with the good work. Witness protection, you are very good in Meru when bringing witnesses in urban areas. Now I'm in Samburu, I make an application, and no one wants to listen to me. Do you want to balkanize this country that in certain areas you protect witnesses and in remote areas you frown?
Thank you so much, Namiti. Will be answered. Give Mr. Onkoba first, then this gentleman, Mutinda, you. Then we get the answers, then we get another round.
Thank you. My concern is with respect to human rights. Now that I have seen how passionate you have brought it out, that we know these offenses are happening. What measures have you taken? How have you prepared? What team have you sent to the ground purposely for evidence collection? Because that is very important. Bearing in mind that our officers are also stretched. That is a fact. Thank you.
Yeah, thank you for the opportunity. I'm Karaoke Jamwitha from the Communications Authority. Though we weren't called to give feedback, I'll also give my feedback as I give my recommendation. I think this was a very good opportunity, and the very thought that the ODPP had in bringing stakeholders as well as the key people on the ground, that's the prosecutors, together to deliberate on this indicates that we are really appreciating the need for interagency government collaboration, which is very important and which we have always sought to enhance. The other thing that I don't want to mention is that the aspect of international benchmark on the way things are done is was a very important aspect in terms of learning. And I was just hoping that in the future, perhaps we'd need 2 sets of training or sessions. One that is in the run-up to the elections, which just assesses our preparedness for the elections, and one that happens soon after the elections, when things settle, because you want to look back and ask ourselves, how did we perform? What did we learn? What things require to be done differently? Because what came out from a number of those international benchmarks is that there are areas where we could probably do better, but those areas, to be able to be implemented, we probably need both policy or legal reforms. Of course, between now and the elections, they can only remain suggestions. And we want these kind of forums to be practical forums that go into helping us conduct our business. And the other thing is, yeah, I've talked about timing and the need to probably consider having two sets of similar sessions. The other thing is, in the spirit of that stakeholder collaboration, I noted that these are largely the prosecutors. And we have learned the need to have a full circle of people who really know what they are doing, the approaches that they want to take in relation to the issues that they are dealing with, as it relates prosecution of hate speech and other election offenses. And therefore, the role of the investigator did not really come out very well. And probably in future, we want to have very concerted, or rather even a joint session with the prosecutors themselves. And given the need, or rather the importance of elections in our country and elsewhere, everywhere, I think it may be necessary for there to be a set of prosecutors who are specifically trained to deal with hate speech and other election offenses, particularly as we head towards elections. Of course, that may not be possible if it has not been done already, but it could be something to consider in the future. We appreciate that it may not be possible to have all the investigators get special training on, not prosecutors rather, but investigators have a special training on investigation of election offenses. But we can have probably 2 in every county who are point persons and who could lead such investigations whenever they happen across the counties. Thank you very much.
Thank you so much. And I'm sorry that we forgot to bring you in front, but at least you've had the opportunity to tell us more, and we really appreciate. Thank you so much. Mr. Mutinda, then that lady, then you.
Thank you.
I will have Mr. Mutinda, then we respond, then we'll go for another round. Sorry for that.
Yeah, in fact, mine is not even a question. One thing, let me confess that my conscience and age prevents me from asking some of the questions. I should be giving answers. Yeah. So what I'm saying and what I'm making is a clarion call. And a clarion call, we are team leaders. We are mentors in this composition. My clarion call, and as it has emerged in these proceedings, is as we go down to our respective counties and regions, the call is, kindly let us take down the spirit of collaboration, 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 and mutual collaboration. Because some things are rising here, and sometimes we like this idea of writing long letters, a lot of English, a lot of all that. That is not a solution, and it doesn't assist Wanjiku. Wanjiku is assisted when you are consulting this officer or these officers, these respected officers, when you are either picking the phone, when you are either seeking either their audience. That would be the kind of assistance and the kind of collaboration I'm calling for. So let's walk the talk. Let it not be we have participated, we have listened to good papers, but we are not walking the talk. Let's go down with that kind of message. Let these guidelines and Competence, let them trickle down where we are, and as team leaders, we will be moving together, and we'll be doing a very good service to the ODPP and to the leadership of our organization.
Thank you so much, Mr. Mutinda, for that clarion call that we need to collaborate. So we need to answer some of the questions, and I'll start with Madam.
Thank you so much. Some of the questions will be answered by the seniors there, Mr. Mutinda. I can see Mr. Mwega here. There's Madam Emily, Madam Wenje. Some of the questions will be able to be articulated, but I can actually talk to some of the questions. Lillian, first of all, asked a question on how prepared are we on SGBV. I can actually assure you that we are so prepared to the extent that we have a rapid reference guide, which we are actually almost finalizing, and it has a relation with how to manage SGBV, especially during election times. But that notwithstanding, even in this training, this is one of the ways we are attempting, or actually we are going to make an impact and ensure that even the prosecutors are already equipped, not just the prosecutors, also how they coordinate and manage such situations. I also need to just let you know that we work very closely with the witness protection. Some of the successes we have had in some of these cases is because witness protection agency has supported us very well and has protected our witnesses. Again, the office itself now has a division that, or a unit that manages witness facilitation, so that we don't have to worry about facilitating a witness. We can facilitate and also ensure that the witness is protected. So that's some of the ways of how we are managing, or how we are prepared. It's challenging to investigate a case even during election violence, but we are trying, and that's why somebody actually reached out to you and asked you how you will, what have you set, what have you put on the ground to ensure that if you can be able to protect the witnesses and the evidence thereof, even after, if at all, there's any violence, we are able to deal with that situation. Now, I think the first person who asked a question which relates to maybe prosecution is Esther. Yes, Esther asked about I mean, there was a most recent decision, the one which Omutata had actually sued the DPP and other parties. It was clearly defined that the role of the DPP is the one of making the decision to charge. No other body has that power. I think that one has been clearly spelled out. And I genuinely hope that you have appealed against that decision, because that was a very bad decision. I don't even want to sugarcoat it, that was a bad decision. The decision to charge is by the DPP and the DPP himself. He actually donates that power to us. So for me, I would appeal to you to appeal, and then we can be able to deal with the issue of the appeal. Namiti, you actually said that we need to have mentorship programs. Actually, and if I think Ms. Wangoi and myself, we had a program where we were, it was actually online. We had a mentorship program, but specifically on homicide. And I think we invited our seniors, Mr. Kemo, Mr. Omwega, Mr. Muteti, Mr. Umtelema. I think these very senior and seasoned prosecutors were actually speaking to them and on the challenges they have encountered, even as they have been pursuing the prosecution. So, but I know again that Rhoda in Ms. Ogoma is working on you know, now kind of a formalized kind of mentorship program. But we are doing it. Even in our small way, we have been doing it. And I think now I'll just go, before we can be able to formalize it, we are going to continue having those mentorship kind of informal programs. They have been very useful, and I think we got a very good feedback. So we have not slept on it. We are not sleeping with this talent. The talent is there, and you can confirm that we have been talking about it. What else haven't I talked about? Have I left out anything? All right, I think maybe my... in addition to what you said... Yes, and then Rhoda can be talking about the coaching and mentoring program. Yes. All right.
Okay, so the aspect of mentorship, I think we had a very heated discussion on, was it day 1 or day 2? When we were actually requesting the judicial officers to hold our hands as well. But just like Jacinta has said, we have had mentorship, and it is informed more by our experience when we joined ODPP, because for us, we were thrown in the deep end. And so even as we have engaged DPP on the aspect of professionalization of prosecution services and improving the quality of our performance in the office, we have said that we do not want a repeat performance of what we went through, because that was baptism by fire. And you will note that currently, or rather in the previous lot of newly recruited officers, who were about 44 of them, we sent them to the field first for what we called placement. And the placement had instructions. And the instructions are that so long as an officer is sent to you, they are working under you, and you're supposed to show them the ropes. We currently have 105 newly recruited prosecutors, and all of them have been sent to the regions, and I know that they have been deployed to the counties and to the sub-county officers. And the instructions that were given to the regional heads then was that they are coming there for placement so that they can learn. And this has had an impact even in our performance, because when they eventually come back formally for induction, I think my colleague Mary will confirm, we have had meaningful engagements because they are talking from a point of knowledge, because they are asking questions about things they have encountered. And that is why it was important for us to add our voice to the clarion call again to the judicial officers not to disregard, but to be encouraging, because that's the only other place their performance is measured, or it's, the quality of their performance is boosted or backed up. So yes, mentorship, we are working on mentorship and coaching as one of the training aspects that PTI is minded to dispense. And of course, that is over and above the actual induction, the continuous professional development, the promotional courses, and the other multidisciplinary courses that PTI offers. And of course, ideas are welcome, because we are moving to the level of now doing our internal training policy, and we want to be very elaborate on what the mentorship and coaching provisions will be in it. Thank you.
Thank you so much, Madam Rhoda. Yes, Jacinta?
Just picking up, one of the concerns she had raised with us is at times a file might have already been brought to court. Maybe the DCI have done it. Then IPOA comes after, and a decision is made to stay. But the provisions of IPOA Act says under Section 26 that we shall not be involved in any matter that is before court or a judicial tribunal. Maybe you could answer that.
I think, and what we have done previously, we have had situations where you find that DCI has investigated a matter, they have a file. Internal Affairs at times has also investigated, and there's also a completed file. And again, you find that IPOA has also investigated. What the DPP has found the best approach to this kind of situation is have the three investigating bodies sit together. We agree on which file to run. Instead of interrupting a case which is already running, we prefer revamping the case which is already on record. I mean, it's proceeding. So we assist using, we have that tripartite kind of meetings which help to avoid, back and forth. I think that has worked for us previously in quite a number of cases. And if you have a case of that nature and you're having a challenge, you have Internal Affairs here, we have IPOA here. We can be able to resolve that one for you.
Okay, yes. Now, one of the things that has come up, and I thought I should add it after Madam Jacinta, when I look clearly at the Constitution, it says the office of the ODPP shall not require any consent in anything they do, as long as it's fair administration of justice and not an abuse of legal process. So you can't look at anything like that unless that's removed from the Constitution. You can decide that you'll charge or not charge, and you're not supposed to be answerable to anyone. So I think that power needs to be guarded jealously, because that is why we have you over there, and it should not be swayed by public opinion. We need an arbiter there. And many times the ODPP has acted as an arbiter between IPOA, IAU, DCI. They have sat us in a room. We actually even went as far to sit down with people from ODPP, with DCI, and we've come up with standard operating procedures on how to prosecute and investigate the cases. So I believe maybe what is important is that we need more dissemination and we need more collaboration so that we can be able to learn and use what is there. Then a little bit on the aspect of SGBV. There's IPOA and Kenya National work together. Kenya National even sits on our board. But the difference between our investigations, theirs is more thematic, looking at how widespread it is, and it's not geared towards prosecution. But ours is more direct and focused. We have the mandate to take up complaints and investigate them. We face several challenges, including the medical legal challenges of documentation. Although we rely on the provision in the Evidence Act, it's escaped me, I couldn't get it, where when the victim's testimony is believable, they can rely on that evidence. So it's not such a big challenge now with that provision. And I think we need to explore and unpack it more. What does it mean? Does it mean when I stand up, I say I'm raped, it's believable? Or is there, because now when we are reviewing our cases, that's the argument we have. Will someone say I was sexually assaulted and it's believable? Or when is it believable or not? Challenges in investigating SGBV is, first, during that period, it's very difficult to establish the identity, more so if it's during a security operation, because at that point, we have security officers on the ground, but we also have the militias and other gangs. So at times, people are not able to differentiate. The second thing is the aspect of documentation. Many of the victims are not able to access facilities or the station. And when they do, the stations are stretched and there's no priority. So it's an aspect of how will we create a framework to prevent abuse, and also how will we treat victims of abuse. Another thing when it comes to the element of SGBV, I think at times there's even double and triple counting. So you'll find ICJ will go to the ground, interview the same victims, someone else goes, interviews. So in the end, you'll have a report saying that there are like about 2,000 victims and no action is taking place. But when you look at the ground, the victims are not there. So we really need to look at it. Then in terms of also the support, we would like to see more prosecution-led investigations, especially when you're working with IPOA. Yes, so that even when a case is there, you can tell the investigator that this is what you can get. For example, the aspect of confessions taken by IPOA officers, you can ask, is it legal, or does it have to stick to what the Evidence Act says? An officer of a certain rank, how can that be remedied? Also, how can we ensure that the file is ever able to move from the investigator to ODPP and back to IPOA as fast as possible to ensure that there is no delay. The other thing that the SOPs we made was the aspect of when a file is brought to the ODPP and it falls within the mandate of IPOA, IPOA is supposed to be advised that the file is there to establish first, have we investigated? Secondly, do we have evidence? Thirdly, if we look at this file, there is not going to be a miscarriage of justice if it goes ahead. So we agree, not all matters need to be strayed in the interest of justice, because our role is to ensure that we have a professional National Police Service. And one of the things that will be the hallmark of the professionalism is when they are able to hold their officers to account without oversight. That's the direction we're moving.
Thank you very much. I just want to respond to Ms. Esther Macharia, but I think he has been responded to well by Madam Jacinta there. But mine is just an input, because this is a case which is, we are very much aware. There was a matter in court, but with us, Internal Affairs Unit, before we go into a matter, mostly of these cases who are pending before court, we normally receive directive from the DPP to investigate and file and forward a file for them for decision. We don't just wake up because a complainant has come and we start instituting investigations. I'll give you 2 examples. There's a case of former OCS Ruaraka. He's called Nahashon. This case is still very much alive to us. This is a senior officer who was commanding a station. The officer used his powers and privileges, took an innocent person, charged this innocent person in court. And this guy was languished in remand prisons for almost 3 good years before oversight bodies came in. The only mistake the person was in prison was because he witnessed the Nahashon, the OCS, committing a serious crime. So the OCS used his powers to arrest this person, present charges before a magistrate to the prosecutions, approved the charges, and the person was taken to court. So only one person who courageously came to Internal Affairs Unit and volunteered information saying, there's a person in industrial area prisons, and this person is innocent. Because this person was present when Nahashon was beating this person to death. So when he presented that matter to us, when we commenced investigation, the same person went to IPOA. And as IPOA has a mandate to take over any investigation over internal affairs, they took over the investigations. So you can see that case is still alive to us. It turned up that the prosecution, having been presented with overwhelming evidence, withdrew the matter and then charged the OCS. So you can see in such a scenario. We also have a scenario, Madam Macharia said in Meru. This was a dispute between an advocate and a base commander. It rose over a very minor thing, over a towing vehicle, because the advocate was involved in a motor vehicle, in a road accident. But the officer came in and he insisted that the advocate must use a certain towing vehicle. And the advocate said, no, it is my right. I have got my insurance, who is going to do ABCD for me. And then there was a lot of dispute until the matter ended up in court. So the magistrate felt that her rights were infringed. She needed a forum where she can be heard. She wrote to Inspector General, as well wrote to Director of Public Prosecution complaining about the conduct of the officer and the matter in court. With us, the DPP wrote to us to gather evidence and submit to them so that they can make a decision over the matter. That is what basically we do. And we found a lot of inconsistency in the police file. We were asking before we went, maybe to your surprise, Madam Esther, we even visited your office, met some prosecutors, and even engaged on a discussion over the matter before we came back to Nairobi, filed a report, and submitted to the DPP. You see, because it's on the realization that we know the decision to charge and or sustain a matter in court is the preserve of the DPP. So ours is just to give you the evidence. If you feel you want to withdraw it, it's well and good. If you will that the evidence the IUS is not enough, still you can proceed. So that is basically what we do. But what we are advocating for, and what we are saying, that we know that there are officers who are working in collusion, and whenever you go for them, there's one thing they normally say: the matter is in court, and this is a citizen, an innocent citizen, is suffering. Where do that person get justice? I think, Madam Ms. Mwenje, if you can recall, before when you were at the quality assurance, we had that discussion, and extensive discussion. There's a matter in court, and the officer is committing another offense. What do? or interfering with the witnesses, or our officers have committed an offense, do you turn a blind eye because the matter is in court or whatever? So I think we should have a lenient approach to some of these issues, so that the officers know that it is not that when the matter is in court, it's enough for him to continue committing other things. What we are advocating is about professionalism. Officers, that is what we have in the NPS. Officers must be professional at all costs and must adhere to Article 244 of the Constitution. Thank you.
Okay, there was a question regarding the competence of the prosecutors. In my view, all prosecutors are competent, but there are those who are more competent than others. Yeah, let's just agree. And maybe for the regional heads, when prosecutors are being posted in the region, you will gauge. You will know who is strong in this area and who is weak in this area. So when you have a matter in court, you will pick who is more competent, and if maybe within that region you cannot get that competence, then you can ask the neighboring region. And I remember when I was working in Mombasa, we had very technical matters that we were dealing with, and there are times Kemo would ask for prosecutors to come from Nairobi, and they did very well. Like Akula did, he did very well in my opinion, although the matter never ended. I was transferred before I concluded the matter. He actually did very well. When I had a weak prosecutor, I talked to Mr. Kemo, and Mr. Kemo gave me a very good prosecutor, and we worked very well. So it just depends on the regional head on how they look at things. Another challenge on SGBV, you see, like the human rights organization, you know, there's fatigue, there's victim fatigue. You see, I was raped. KNCHR comes and you're asking me, and you are not even sensitive how bad it was. ICJ comes, another organization comes, Kituo cha Sheria comes, they're asking the same things. And you know, for women, when you are raped, you don't even want your husband to know that you are raped, because you know that will be the end of the marriage. That man will never touch you when he knows another man reached there. So you find victims, most of the victims, they'll say, apana, hata hakunifikia. Alikuwa tu karibu kunifikia, lakini nikapiga nduru, hakunifikia. And you know, they are telling you that, and they are hurting, they were actually raped. So maybe we must find strategies on how we are going to deal with this SGBV. And then secondly, SGBV is not only about women, even men get sexually violated. I dealt with a case where, and it was very traumatizing, where this man was sexually violated by 5. The other challenge is, you find that where a very influential person has committed a sexual offense, they trade. They get a weaker person to go in and, you know, to be the sacrificial lamb. So, you know, the person who is charged is not actually the one who committed the offense. And this influential person is, and when I talk, I don't want to name names because I don't want to be quoted and charged with defamation. But you find that this influential person picks the most innocent person, and he agrees. He agrees to go and stand there as the accused. So they'll come and process the bond. He'll be given bond. And as you are sitting there as a magistrate listening to the case, the victim saying, siyo huyu. And you see, that case, it collapsed from the beginning. So those are the challenges. I can't remember the other question, but maybe I agree with the prosecution. Mentorship is very good. When I was doing my studies elsewhere out of this country, we were told that when the prosecutor is standing, you ensure that as you are standing to talk to the court, your case is also standing. If your case is collapsing, you don't stand at all. So we also don't want to hear a prosecutor coming and standing before me 5 times. Your Honor, I have not received the police file. Don't stand. Deal with that officer who is not producing the police file before you come to court.
Yeah, Mr. Namiti asked that question, whether we process applications from, you know, certain areas and leave other areas like Samburu. Yes, I want to agree that we might have offices in 3 areas at the moment, but our coverage in terms of processing applications, we do across the country. We've had cases in as far as Turkana, Lamu, Garissa, Isiolo, and I think Keprop can attest to that. We interacted with him when they were handling terrorist cases. But for your case, I'll find out and see where maybe the application did not reach our office, because we also have our SOPs, which guides us, and also the PC, which guides us on how many days you're going to take to acknowledge your application and process it. So I'll follow it up, and then we will do better, maybe. Thank you.
I think you want to say something?
Okay, I had an opportunity to work at the Witness Protection Agency. Okay, let me just say, because I no longer work there, but I had they have very good standard operating procedures, and when a request reaches and they have done the assessment, they actually protect witnesses from all over, from all parts of the country. At one point, when I went back to the judiciary, people were saying that this must be an NIS, because how come she has worked almost everywhere? But I just worked almost everywhere because I had to put bread on the table.
Thank you so much. So we are going for another round of questions.
Yeah,
and I'll start with Sorry.
Yeah. I was asked a question on the preparedness of the commission, and I think before I say that, let me just add another agenda that we're experiencing a lot of violations during the election, the intersex persons. We are having a lot of violations for the intersex persons because most of the people don't know how to handle that gender when it comes to matters, violations during election. Having said that, I forgot to introduce the commission when I was beginning to speak. So we are a constitutional commission, and our rights is protection and promotion of human rights under Article 59 of the Constitution of Kenya 2010 and the KNCHR Act. So we do this by acting as a watchdog. And also we do the protection by giving advisories and also now doing our reports, as the reports I was talking about. For the election 2022, we launched our election strategy on 15th December 2021, where we will be monitoring the 2022 elections in 3 phases. The pre, that is right now what is happening, the illegal campaigns that are happening across the country. I'm calling them illegal because you have seen the IBC calendar. So these are illegal campaigns, and you're having serious violations perpetrated during these illegal campaigns. Also the nominations. So we'll also monitor during the election period and the pre and the post-election period. So we'll have a 3 sort of phase monitoring strategy. So what we are doing as a commission, we have done consultative meetings with various actors. We have trained security agencies on a human rights-based approach on election, the use of force and firearm. They are supposed to use reasonable force. But how reasonable is this force? Can we have a human rights-based approach when we have these police officers going out there and restraining, for example, these crowds during demonstration? We have different consultative meetings with different actors, especially to have an input on our recommendation matrix, on our reports 2017, and deliberate on ways forward. We have done hotspot mapping as a commission, where we have identified areas where we see there's sort of hotspot when it comes to election violence in the 2022 general election. And then we are also in the process of finalizing our spot check in these counties, where we are going to these different actors, evaluating and looking at how prepared are these actors, the IEBC, the police officers, these hospitals, how prepared are these actors when it comes to the election 2022. We've recruited and trained election monitors who we have deployed in different parts of the country for the purposes of monitoring election. And I can confidently say here that we have trained these monitors when it comes to evidentiary threshold, because the commission is so key on the commission is so key on credibility of the data that we receive for our reporting. We have an election monitoring system. That is, these monitors in the ground, they are going now from their monitoring work, they'll be sending reports to the election monitoring system, where we have a team of data analysts and staff from different departments of the commission who will be seated at the election hub to do the validation of these reports. We'll be looking at the witness statements, we'll be looking at the evidentiary gap, and calling these monitors from the field to give us more details about the incidences. What else we are doing? We have set the election hub, but as I had said, that consists of 6 data analysts and staff from different departments of the commission, who their work is generally to validate these reports in terms of credibility of that information from monitors, in terms of the evidentiary threshold, because we are so key on the credibility of our reporting. We also have a toll-free number, and if you allow me to say it, it's 0800 720 627. 0800 720 627. This toll-free number is open to members of the public. They'll be calling to launch their complaints with the commission, and then we'll dispatch a team to go and do follow-up. I think that's briefly our preparedness towards the election. Thank you.
Wow, that's so nice. That's so good. I think they need a clap. They are really prepared. It's so good.
Let me add something. There exists a referral mechanism that ODPP is very strong in. Mary, we miss you. Come back to complaints. So there's a very strong referral mechanism where whether a victim comes to ODPP, they are handled at ODPP. ODPP does what you call a minimum facts interview and refers that information to the next agency. So this prevents the double traumatization. So it's an agreement between all especially the government agencies that work on human rights violation, that we don't send one person to another. Now I think that because we are so networked, we now don't have the issue of forum shopping. Someone will go to the judiciary. I know you've seen letters from us. It's not to question your mandate, but to ensure that there's no duplication of efforts, right? So that once you receive that letter, all you have to say is the matter is before us, we are seized of the matter, or we are not aware. So there's the referral mechanism, and when you come across an issue, as long as you can get in touch with one of the government agencies, be it CAJ, be it Witness Protection, be it ODPP, IPOA, KNCHR, we always work together. And that's why I was saying, you people might not know, but we as the complaints department, there are a lot of things that don't reach you. We deal with them before they are escalated, and many times in a very discreet manner, because we get a lot of vexatious and frivolous complaints. And we're able to assess, we're able to discuss, and we're also able to now wind up. So I think complaints departments need a hand clap from you guys. And also a hand clap for Mary, because she was like our very senior, and she's the one who actually drummed the thing of Article 157, where she would tell us, we are independent, you have no business questioning the same. So you should thank her. That's why all of us are all saying, yes, we'll give you the file and you make the decision. That is her work.
Thank you so much.
So you need to know that.
Yeah, and just to add on monitoring, we are also partnering with different institutions. For this election project, we are working closely with FIDA on SGBV. So maybe the Lady Justice here will be guided the fact that we'll not have conflicted data from different institutions, because we have decided to do a partnership sort of approach when it comes to our reporting and our monitoring. We are also working closely with IPOA. We actually trained their staff last week on our election monitoring program. So really, we are prepared. I've also read the compendium on electoral justice from the ODPP, and I'm seeing that we are part of the key ODPP stakeholders. Thank you.
Thank you so much. The last
Maybe
round
the last
of questions.
Mary, I'll give you a contact of somebody who was instrumental in training the very good police prosecutors, so that they can also work closely with you, so that we can have very good prosecutors, just to guide them. I'm not saying that the prosecutors are bad, but just to help them to see how do you arrange your file, how do you have an inventory of exhibits that, you know, before you even go to court, you know that this exhibit, these are the exhibits, and when the witness mentions an exhibit and is the crucial witness to produce the exhibit, you ensure that that exhibit has been produced. And then for the judiciary, all the SGBV cases, we hear them in camera. That is to protect the dignity of the victim, irrespective of whether they are male or female. So even divorce cases, we hear them in camera. So because so many things come out in divorce matters, and we just don't want everybody laughing at it on social media. Yeah.
Just a quick reaction to Madam. I think, Madam, allow me to just let you know that we have professionalized our prosecution, and we are not going backwards. We have our own prosecutors, and I am even starting with them myself. I mentor my prosecutors every other day. We can't allow ourselves to move backwards. We provide prosecutor guided. Sincerely, at least let us not go back there, because that means we are going back 10 steps back, 10 years back. We have left there. And that's why you find Mr. Mwega was sitting here confidently. Mr. Amaroro, they're all here. Sincerely, madam, allow me for that one. Let me tell you, that one we are not moving back 10 backs. Yes, thank you so much. Yes, yes. Yes. All right, thank you so much.
Yes. Actually, mine is not a question. It's just an addition to the question that was asked by my colleagues about the IPOA and the internal investigations units. And I know my senior and all the panelists have spoken about this issue, but I thought I have some practical experience that I would want briefly to share for the benefit of my colleagues. Now, I understood their questions also to touch on the issue of the process and the harmonious working together of the prosecutors, IPOA, and the internal affairs unit. And I speak of my experience for these 3 reasons. Between year 2020 and 2021, I worked on IPOA files, working under Madam Nyamosi, my senior, and also some files from the internal affairs unit. So firstly, then later I had an opportunity also to defend an appeal, a conviction that resulted from IPOA investigations. I think it was a former OCS, it was called Katito, I think the nickname. Yes, at the Court of Appeal, and now I'm serving as head of county. And so I have that, different experiences. Now, my understanding, number one, my lesson is that all the files from my IPOA and the Internal Affairs Unit, they come directly through the office of the DPP, where DPP looks at them, or an officer who has been assigned looks at them, and then gives their comment. Now, one thing that I observed is that all those files in the from investigations to the findings, they will speak about whether there is a matter that is already in court. touching on that issue, and the officers, both from the Internal Affairs and IPOA, will make recommendations. Now, what we were doing, and I realized that was a practice, is that when we are taking back the files, we will also make our recommendations on the fate of the matters that are already being tried. Therefore, it will be seen that when now the officers now liaise with our prosecutors on the ground, the decision of the DPP or the directions of the DPP on that issue is already in that file. So maybe we need to be checking properly on the subfile J on what the DPP are saying, because I don't think it should be able to contradict the changing decision that had already been arrived at the grassroots level. The other issue that I found was that it is true that IPOA will not take over investigations of a case that is actively before court. And actually that issue was raised in the Katito appeal, but we were able to demonstrate that before IPOA came in, DPP, actually our former DPP, withdrew the matter that had already been filed. So there's no contradiction at all, and that appeal failed at the Court of Appeal. The other point, finally, the other point was that as a county head, I've received a letter from communication from Madam Nyamosi with some documents about investigations by Internal Affairs units touching on matters that we are prosecuting, and all that she was asking me to do, and I think there's another point I would want my colleagues to note. She told me, look at the recommendations of Internal Affairs unit in view of the prosecutions that you are doing, and you make the right decision, or you review the changing decision based on what the Internal Affairs unit are saying. So I think we have all these three options. Either we have directions from the top on the fate of the trials that we are already conducting, or at his discretion, the DPP can ask you to review your changing decision based on the emerging new evidence. That is all.
Okay, good afternoon. My name is Barbara. I'm a prosecutor based at Mombasa. I have a question for Mr. Biwota from the Witness Protection Agency about timeline. Why is it that when we do correspondence regarding an individual who is supposed to be placed under protection, it takes time for them to finalize the background checkup and all that? I'm asking this because I had two scenarios where a witness who was supposed to be placed under witness protection, we did the correspondence and it took long, and the witness was finally killed. So we had to do another inquiry onto the murder of this witness. Even my colleague, Mr. Feather, was even sharing his scenario where a witness was killed by the Al-Shabaab and his head was taken to those sides of Lamu as they were waiting for the respondents on whether to place this witness under witness protection. Don't you think you need to come up with mechanism, or maybe a place where you can place them as you finalize your the background checkup, or to see whether this witness meets the threshold to be placed under witness protection?
Thank you so much, Barbara.
Now that we are at the tail end of our learning, we are walking out of this institution with a lot of knowledge, prepared to handle the issues that we are supposed to go back and handle. But we are living as generals. The foot soldiers on the ground, they have not gone through this training. But I'm directing this question to the seniors who are seated there, and more specifically Mr. Omwega. would he mentioned something several in one statement, and this is with regard to strategy. What could be the correct strategy? Because with the knowledge that we have, we actually need a strategy such that we can be able to attack. With all the guns that we have, with all the uniforms that we are wearing, we need that strategy. What could be the strategy? Because you didn't reveal the strategy actually.
Thank you, Mr. Okemu. When we had a short discussion yesterday, I asked about the strategy and what informed that kind of approach is because I had an opportunity to prosecute matters relating to post-election violence in 2007. I have also had an opportunity to prosecute matters relating to coercion, several of them, of course. I have happened to have worked probably areas you may classify at hotspot. I have also had an opportunity to do the reading on matters relating to election. I have also listened to what they are saying. And we had a short meeting yesterday, and those of you who arrived there, of course, I'm not throwing it to you. And I saw there is also a program coming after, in the afternoon, on prosecution electoral offenses, scoping session and management, and facilitation. But probably I may not speak at that time. One of the strategies probably I will be sharing with Mr. Kemo is to see how we can compare the challenges we have gone through, and more specifically, what we went through in 2007. And I remember, I can see my colleague, Mr. Gitinji was around. We were members of the National Maritime Task Force on Post-Election Violence. Of course, we will have to look at those documents and review them, and I hope Madam Rota is listening. In the next lane of training, we should be able to have practical approaches to the challenges we have gone through. I listened to Madam Yarod the other day. I learned one thing from her, and probably is one of the strategies that what she said is going to assist us come with a strategy in terms of when we are asking for time to investigate and have somebody in custody. That's what I picked. So for avoidance of ambiguity, that's the issue I picked. And then we'll work on it. But to add on what the panelists have commented about, we, in terms of mentorship, those who have worked with, would agree that once in a while, I walk around and discuss with them on specific matching legal issues which have been dealt with by the Court of Appeal. I am happy to have about 2 with me here. I may not mention their names, they can bear witness. And I will tell you, like, from the point of Madam Madam from Meru, the issue of that High Court stopping, if you get time and liars with Mr. Mure, he had dealt with a matter where the Court of Appeal pronounced itself on what's supposed to be done, depending, and it touched on the powers of the DPP, as Madam Aipoa was saying. Let me call you, allow me call you Madam Aipoa, because I may, for lack of your name, I have not mastered your name. They went ahead and also compared, in that judgment, they have also compared it with the case from the state of Maharashtra. They went into more details and they have a solution to it. As Madam Nyamos made it very clear, that was an outrightly wrong decision. And on the issue of sexual and gender-based violence, if you get time, you can check their Court of Appeal decisions on proof of fact of rape without a medical report, with direct evidence. One is somebody, Mutuku. I have the authority with me, but I may not give you. They have said you can prove the fact. I may not have the full names. You can prove the fact of rape without necessarily even having the medical report. Of course, it has not been accepted in the subordinate court, but there is that court of appeal decision. We are also aware of Section 124 of the Evidence Act in terms of evidence relating to a child who is a victim of rape. At an appropriate time, I hope my senior Mr. Kemo is around. He joined this place earlier than me, and we acknowledge that. We will have a discussion with him and probably come with the thematic areas in which we can, and Madam Rhoda, we can commence informal mentorship programs. That will work. And in terms of strategy, I hope he will come with it, and if we won't exhaust them today, I will be engaging him so that I have had people who have been trained before, and when they come to me, you realize some loose ends. And when you ask them further, they give you a report of the training they have gone through. And probably it's because some of us have worked for quite a long time in the villages. We will work on the strategy. The training, Mr. Kemo, for our prosecutors is a must if we want to have an impact. And it must be practical approach now to really prosecution, the really thing. And one other strategy probably is, let's ensure when we go to the local areas, we get all the participants together and get an opportunity to look at their documents which relate to election preparedness, so that we may also harmonize to afford, so that we can foster what my learned colleague senior, Mr. Mutinda said, collaboration, but collaboration without conspiring. Collaboration without conspiring. Collaboration as you uphold the rule of law. I think that I suspect Mr. Kemo will dwell on that strategy in more detail. Thank you.
Thank you so much. Mr. Kemo, maybe you can comment, then we can have the last responses. We break for lunch.
I think Mr. Mwega and Mr. Okemwa, the afternoon session will be for that very purpose you've spoken. And maybe you just hold your thoughts until the afternoon, when we will discuss some of the strategies we can deploy to ensure that these cases are well handled. I have some ideas, and no idea is bigger than anyone's idea. So think about it even as you go for lunch, and when you come back, let us have your suggestions. And they should be practical things that we can be able to implement and work. Lakini yote tisa, lazima sisi wenyewe tuwe na moyo wa kujituma. The seniors must hold the hands of the juniors. There are certain basic things that we need to know. Those of us who've worked in Nairobi, you know, in high-profile cases, we work in teams. And the advantage of that is when you are looking at a case alone, sometimes you have a mental block. I have read files over and over again, but when a junior colleague came and read it, they made a suggestion that made a whole difference in the matter. So learn to discuss. When you have a high-profile matter, create a small team, and you'll be surprised at the ideas you'll get from your colleagues. I think the afternoon session will address that issue.
Thank you so much, Mr. Kemo. I think the last question was to the IPOA about how people can respond. Witness protection, sorry. You can protect the measures you can take before someone's head is found somewhere.
Thank you for that question. It is very unfortunate that a witness had to lose his or her life, and though I am not aware of that a witness, I left Mombasa like 4 years ago, so I might not be, and because also the nature of our operations, it's very covert. So I might be having a colleague who is handling that witness, and I might not get the details of the witness. But having said that, let me say that admission process takes time. Or admitting a witness into the program, it's a process. It's not one day affair that we are saying that today you come and we admit you. It is a process starting from the application that we receive from referral bodies, prosecution included. And though we have one of our measures is also we evacuate witnesses. We do temporary relocation depending on the cases that we receive. If the referral body says that this witness is in danger right now, for example, there are some witnesses whom we've evacuated from the police station, from the prosecution offices. They call us and we respond immediately. So that one is there, that measure is there. But the other part is now the process of admission. Starting from application, we do an interview, we do risk assessments, that is thorough risk assessments, where now we meet the prosecutor, the police, and other people in the process of doing our background checks. When that decision will be made, it will be the director. By the time I'm sending my my recommendation to the director, maybe it has taken some few days, but not so many days, like not so many days. Like I said, the decision is with the director, but currently we are improving our standard operating procedures so that we reduce the number of days. Maybe if it were to take 3 days or 4, then we are in the process of improving the SOPs, and I think we are at the validation stage. But it's unfortunate. I promise that we will work on it. Thank you.
I think we need to give a clap to the panelists for the good work that they have done. You can attest that we have really learned so much this session, and we are really better equipped for the task ahead of us. So thank you so much. And with that, all of us have earned this coupon. Then we can go for lunch. The next session, I think, should start, what's the time? It's now 1:15. So we start at 2:15. Thank you so much. Enjoy your lunch.